My name is Jennifer Felten, and I'm the owner of a law firm called RELAW APC. The question about RESPA has to do with the anti-kickback laws. So RESPA stands for the Real Estate Settlement Procedures Act, which is a federal law. Section 8 of RESPA is actually the anti-kickback section. So when we talk about RESPA, that's often what people are talking about. But most states also have their own laws as it relates to anti-kickback. So not only is there federal law, there's state law, California, that impacts both realtors, escrow companies, title companies, everyone in the settlement industry. So there's actually multiple layers of laws that are often kind of grouped into that title of RESPA. Anybody can own an independent escrow company. Almost anybody can own a title company in California. There's a lot of cost to entry, but ownership can be pretty much anyone. Just because you have a license does not prohibit you from ownership. But if you are an owner, you have all of the risks of an owner as well as potentially the benefits. So if the escrow company is losing money, then you would have to put in your share of the money if they're losing money. If you buy in, you have to pay fair market value for the cost of the stock. And when it comes to any sort of profit that you would make on it, you're allowed to make whatever percentage of profit there would be relative to your ownership. So if you owned 1% of an escrow company, you could get 1% of the profit. That's the only way that it's legal. So it is legally allowed for them to own. A large number of independent escrow companies are owned by brokers or agents. But it's not a get-rich-quick scheme. It is a limited area where you're taking on risk and liability. If the escrow company gets sued, you get sued. You potentially could end up having damages or costs or liability as an owner, just like any other owner of a company.